that we've reviewed this small selection of some of Alice's abusive behavior, you might think, gosh, this looks like a pretty black and white situation, right? She's obviously an abuser. She shouldn't have the kids. But the reality is that both life and the law are usually quite a bit more complicated. So we're going to take a look at how these domestic violence findings are going to factor into the custody trial. We're going to start by looking at what the current situation is and what the parties are asking for vis-a-vis custody. So you'll remember that when this relationship fell apart, Ioan moved out of the family home. Alice remained there with the children. And so currently Alice does still have primary physical custody of both of their daughters. Now, in his divorce petition, Ioan requested joint legal and physical custody. Alice, in her response, is requesting sole physical and legal custody with visitation for Ioan. So what do these things mean? Physical custody is simply where do the children live? What's their primary place where they spend their time, have their belongings, and things like that. Legal custody involves the power to make decisions on behalf of the child. So where does the child go to school? Does the child have a religious upbringing? Does the child play sports, engage in activities, get medical treatment? Things along those lines. So from this counterpoint, you can see Ioan is attempting to request a co-parenting arrangement where both he and Alice have say and input into the children's living arrangements and just the decisions that go hand in hand with raising children. Alice wants the children all to herself, with Ioan to have the ability to visit them from time to time. There have been a variety of visitation, shared custody types of arrangements throughout the course of this dissolution, pretty much from the very beginning. And some of that has varied because of Ioan's work schedule. Some of it has varied because of just various apparent conflicts that are going on between primarily Alice and Ioan, but also to some extent with the children as well. There's a lot, of course, that I've said before we have not gotten into with respect to the parental alienation. I am being light-handed on this subject, largely out of concern for the children, particularly the older child who's at a point where she is becoming mature. She is entitled to have her own mind, become her own person, and I don't want to discount that children can have legitimate grievances, upsets against one of their parents that can be a difficult thing for them to deal with. So I don't want to potentially invalidate the child's perspective on this situation. The child is living it. And so in that respect, certainly has a lot more insight into it than I do. But at the same time, the child is still a child and doesn't always have insight into the types of pressures, manipulations, and just other factors that can influence how that child sees the world in light of, what they see, what they hear, what they're told, especially when another parent is involved in that influence. In July of 2022, shortly before we're set to go to court for this restraining order hearing, Ioan filed a request for temporary custody orders. This basically means that while the case is going on, they are, from his perspective, no longer able to work out the details of the co-parenting between themselves, and they need some intervention from the court. So in his request for orders, Ioan is asking that the children receive individual therapy, reunification therapy, which is relating to the alienation issues, and he's asking for shared physical custody, 1 week on, 1 week off type of arrangement. What they actually have at this point in time is based on a stipulation that was entered into in about September of that year. So Ioan had filed this petition, this request. Alice is unrepresented by an attorney at this point in time. We go through the DVRO hearing. The DVRO is issued, and then a few weeks later, Alice decides to go and get her attorney. So she's got a new attorney on board while all of these things are now being kind of developed for the court to make a decision about. So the new attorney wants to continue it, and they're able to reach an agreement where Ioan says, great, we'll go ahead and kick out this request for orders. We won't have a hearing on it right away, as long as you agree to some interim types of arrangements that will start to address these concerns. So start to get the children into therapy, start to have at least some type of increased regular predictable visitation. And so the current schedule provided for Ioan to see the girls every Saturday. However, as time has gone on and as things have unfolded based on further declarations that the parties have submitted in this case, it's become clear that that has not been reliable. Ioan has not been able to consistently see the girls, nor have the girls been consistently engaged in therapy as it was agreed that they would do. So based on that, the custody is still up in the air. And as best as we can tell, it's currently set for a custody trial in July of 2023, so a few months down the road here. Until that happens, there's really nothing permanent in place. There's just their stipulation, and it already appears that that doesn't necessarily have a lot of teeth. So this is a very, I'm sure, challenging and difficult situation for them to be dealing with. So why shouldn't the domestic violence finding just make all of this real easy to resolve, right? She's committed domestic violence. She shouldn't have the kids. Let's go ahead and turn to the law to look at what the court is going to consider when it makes a custody determination and talk a little bit about why that is. In the United States, parenting your children is a fundamental right. It's protected by the Constitution, and it's something that in certain circumstances, a parent may have the ability to go to court and enforce. But the problem is when you get into a divorce setting where you can't work this type of thing out by yourself, you're going to have to go to court and ask the state to fix it for you. So your rights are going to have to give way to the ability of the state to resolve your dispute. There's a doctrine called parens, patriae that sort of covers the state's role in this type of context. The idea is that children are a resource of the community. Yes, they belong to the parents have rights, but the state certainly has an interest as well in making sure that children are brought up, that they are educated, that they are not abused, that they are fed and clothed, and all of those types of things. And so those interests are what justify intervention when you get involved with like CPS and things like that. Basically, the parents' rights in that situation give way to the state's power as parens, patriae to come in and ensure that the child's needs are being met. So these things kind of come into conflict. And what that ultimately means then is that if you can't work out your own child custody dispute, the state's going to decide it for you, and they're going to decide it based on what is in the best interest of the children. So there is a strong presumption that contact with both of your parents is in the child's best interest. Particularly when you get into bonding and attachment and childhood development, continuity of these types of relationships is extremely important to a child's development, and any disruption can be very damaging. And I say this for emphasis that even removing a child from an abusive parent is potentially going to be damaging to that child. It's going to be a traumatic experience. We see this in CPS types of cases all the time. The problem is simply that the harm that the child may be facing in the home environment is worse than the damage that they're going to suffer by putting them through this separation process. So there's a recognition that this is not something that you do lightly, even if you don't like somebody's parenting, even if you don't necessarily appreciate a lot of the decisions that they're making. If they're not actually putting the child at risk of serious harm, it's hard to justify inflicting that type of trauma on the child that's going to inherently result from separating that child from its parent. California law even drives this point home in that they have a statute establishing that if there is an agreement between the parties that joint custody is in the child's best interest, the court's going to follow that presumption. It's going to apply it. So very strong incentive here for parties to agree between themselves that we can work it out, we can jointly parent, that's going to be what's best for the children. And when they reach that recognition, very strong likelihood that the court is going to go along with it. But if the parents can't agree and the case has to go through a custody trial, then there are very specific factors that the court is going to consider in deciding what is in the child's best interests. So they're going to look at the health, safety, and welfare of the child. Is the child secure? Is the child being exposed to unsavory people? Is the child being fed, being taken to school? Is the child being emotionally taken care of? A history of abuse by one parent or any other person seeking custody against any of the following: the child, the other parent, or the significant other of the other parent. Abuse against your former spouse and his new girlfriend is very much going to be a factor that the court considers. We're going to get back to this too in a minute because it's actually a little bit more than that. The nature and amount of contact with both parents. The court recognizes that if the child isn't particularly strongly bonded, it doesn't do the child a lot of good to pull that child away from the parent with whom they're comfortable and, place them for extended periods of time with a parent that they hardly know. So you don't get to vanish from your child's life for, the majority of the child's childhood, never form the bond, never really develop a relationship, and then show up at a later point and decide, you want to be involved. And so you're, going to instantly be entitled to joint custody. That's really not how it's going to work. So the court is allowed to consider, if you have not made an effort to be a parent for your children, then you aren't necessarily going to be rewarded with the opportunity to parent the children. The habitual or continual illegal use of controlled substances, the habitual or continual abuse of alcohol, or the habitual or continual abuse of prescribed controlled substances by either parent. Substance abuse is so strongly correlated, not just with violence in general, but also with domestic violence. It's strongly correlated with child abuse and neglect. I have a hard time. I did, CPS work for a number of years when I was practicing in, small town. And dozens and dozens of cases. I would be really hard pressed to come up with a single one that didn't have substance abuse somewhere involved in there. It's just extremely common. So this is something that courts are very attuned to. They're aware that these things kind of make it difficult to be a healthy parent to your child. If you're drunk all the time, you're not going to be supervising the child well. You may be abusing the child. You may be neglecting the child. It just increases the risk and exposes the child to behavior that is damaging, that is, not a good example, and so forth. So very much going to be a factor that the court considers. And finally, specifically in California law, you're not supposed to consider the sex, gender identity, gender expression, or sexual orientation of a parent, legal guardian, or relative in determining the best interests of the child. The statute says these decisions are to be gender neutral. It doesn't matter if you're talking about the mother. It doesn't matter if you're talking about the father. There's no presumption that one is a better parent than the other. There's no presumption that the child will be better off with one than it will be with the other. So those are our 4 factors here: health, safety, welfare of the child, history of abuse, nature and amount of contact with both parents, and any habitual or continual use of controlled substances, alcohol, or prescription drugs. So we can see from what's already been filed in this case that Alice is really hanging her hat on this 3rd factor, the nature and extent of the contact between the child and both parents. She's trying to argue, I've been the primary caregiver for the children. I've raised them. Ioan was away working. His visitation hasn't been regular. Trying to, create this scenario where he's not an involved parent. He doesn't care about the children. Just, coincidentally happens to align really well with this parental alienation motive. But that's going to be a problem for Alice because these factors are not all weighted equally. And particularly when it comes to domestic violence, there's a separate statute that makes that one extremely significant. That's Family Code Section 3044. That section says, upon a finding by the court that a party seeking custody of a child has perpetrated domestic violence within the previous 5 years, there is a rebuttable presumption that an award of sole or joint, physical or legal custody of a child to a person who has perpetrated domestic violence is detrimental to the best interest of the child. Pursuant to these other sections, the presumption may only be rebutted by a preponderance of the evidence. What does this mean? This means that the court is going to assume you're not going to get custody of this child unless you can prove to them that despite this finding of domestic violence, the children are still better off with you than they would be with the other parent. So then what the statute says is that to overcome this presumption, you have to both prove that it's in your child's best interest for you to get custody of them, but also that these additional factors on balance favor giving you that award of custody. And so here's the specific additional factors that the court is required to consider. The perpetrator has successfully completed a batterer's treatment program that meets the criteria outlined in a section of the Penal Code. This is very common when there's a criminal conviction for a domestic violence offense, that as part of the condition of your sentence, you're going to be required to complete a anger management or domestic violence awareness type of program with the goal of, hopefully you developing some insight into your behavior problems so that you can avoid being abusive in the future. The perpetrator has successfully completed a program of alcohol or drug abuse counseling if the court determines that counseling is appropriate. The perpetrator has successfully completed a parenting class if the court determines the class to be appropriate. The perpetrator is on probation or parole and has or has not complied with the terms and conditions of probation or parole. The perpetrator is restrained by a protective order or restraining order and has or has not complied with its terms and conditions. The perpetrator of domestic violence has committed further acts of domestic violence. And finally, the court has determined that the perpetrator is a restrained person in possession or control of a firearm or ammunition in violation of the law. So these are essentially rehabilitative types of considerations that the court takes into account here. They're looking at, has this problem been nipped in the bud? Has there been some steps taken to prevent recurrences of this? Are we starting to develop a track record of being able to comply with the order, being able to interact in a way that is not abusive? This type of growth and development will be very positive for the court. The court will look kindly on those types of actions. By contrast, if you don't do those things and you just kind of, stick your head in the sand and live your life in denial about the nature and extent of your abuse problems, then it's just, you're making it a lot harder for the court to be able to find in your favor on this issue. So if you're a family court lawyer, okay, and your client has got a domestic violence restraining order, you are advising your client, go do these things, go do this treatment, at least get some counseling, go, do drug and alcohol, get an assessment that shows that you don't have a problem. If you do have a problem, get the treatment, follow up with the treatment. Stop violating the restraining order. Stop being abusive to your other spouse. These things are in your interest and in your children's interests, okay? Let's remember what this is all about. This is all about making sure that the children are in an environment where they are going to thrive. So that's what you would do if your goal in this undertaking is really to get the custody of your children and to get it in a way that is going to be beneficial for them. The statute also tells us a little bit about what it means to make this finding that somebody has perpetrated domestic violence. And what they mean is that the person has been found by the court to have intentionally or recklessly caused or attempted to cause bodily injury or sexual assault, or to have placed a person in reasonable apprehension of imminent serious bodily injury to that person or to another, or to have engaged in behavior involving but not limited to threatening, striking, harassing, destroying personal property, or disturbing the peace of another, for which a court may issue an ex parte order to protect the other party seeking custody of the child or to protect the child and the child's siblings. Those are the findings. They may sound a little bit familiar, right? Because those are the findings that the court needed to make in order to issue the domestic violence restraining order in this case. So, yeah, what this is basically telling us is by the time you've got that restraining order, this presumption is going to apply. So just something that you probably would want to bear in mind as you're evaluating your strategy in the case going forward. So this hopefully has made it clear how Alice really shot herself in the foot big time when she decided to blow off this restraining order hearing. The domestic violence finding puts her in an extremely defensive position going into a contested process like that. She has a burden of proof now to convince the court. More likely than not, it's in the child's interest to be with her. The presumption there is very much against her. And you might then be wondering, well, if this puts Ioan in such a strong position, why isn't he pushing that harder? Why isn't he doing something with it? He's been struggling to see and develop and maintain the relationship with his children since the time of the breakup. It's been inconsistent. He's supposed to be getting this 1 day a week right now, but there's still all of this interference going on. Yet he's not bringing Alice up on contempt. He's not trying to bring her violations of the restraining order in front of this civil court, where, by the way, there is a lower burden of proof to establish she's in contempt and civil contempt of a court order. than to prove in a criminal court beyond a reasonable doubt that she committed a criminal violation. But he's not doing any of those things. His strategy is very much not balls to the wall. And so a lot of people might be wondering why that is. So in the next video, that's what we're going to talk about. We're going to talk a little bit about strategy, about the legal advice that a lawyer is going to be giving the clients in this situation. And hopefully we're going to be able to shed some light on possible reasons why some of these decisions are being made. So stick around and I'll see you in the next one.